case to come before the court is State of Ohio v. Harry Hicks. Are you both ready to proceed? Are you?
Yes, Your Honor, proceed.
Okay. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. I'll be keeping track of the time, so if you would let me know how much time you would like, if you do want to reserve time, that would be great. Arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the names of children, minors, or victims, should that be relevant. And you can refer to those folks by initials or terms like the child. The judges have read your briefs, and at this point, I would ask the appellant, would you like to reserve time for rebuttal?
Yes, please.
Okay, and sir, how much would you like to reserve?
Let's go with up to 5 minutes.
Okay, very well, then you may proceed when you are ready.
Can you hear me okay?
We can.
Good morning, Judge Sutton. Good morning, Judge Carr. And good morning, Judge Stevenson. Paul Meyer for appellant Harry Hicks. I'd like to begin my argument with a little prologue, if the court will indulge me. Back in 1977, I came back to Ohio after serving 3 years in the U.S. Marine Corps as a judge advocate. When I got back to Ohio, November of 77, I didn't have any clients, I didn't have a job. Kind of went around to the judges to say hello. I learned that a staff attorney for the 9th District Court of Appeals who had been hired had not been able to pass the bar exam, so there was an opening in the Court of Appeals. And I was fortunate enough to get the position as a staff attorney and a law clerk for Judge William Victor. We had a tremendous court back in those days. Sam Bell was on the court, and also Edward Mahoney. And the reason I'm mentioning this time is Judge Mahoney took me aside after I began work at the Court of Appeals, and he explained that in a criminal appeal, he told me the appellant has a right to a fair trial, but he does not have a right to a perfect trial. And that has stayed with me over the years, and I think it's especially applicable to the case under consideration. Because the appellant in this case, Mr. Hicks, did not have a perfect trial. There's no doubt about it. I don't think the state of Ohio will argue with that. But we believe that what happened in his trial, and I did not try the case, but we believe that what happened during the course of the proceedings amounted to a denial of a fair trial. It begins on the very first day at the outset of the trial when Mr. Hicks' attorney moves the court to withdraw from the case. He cites a breakdown in the attorney-client relationship, no communications, no trust. He says to the trial judge, "My client regards me as another prosecutor." It also turns out that the day before, from the jail, Mr. Hicks had called his sister, and of course the jail calls are recorded, and during the course of that conversation, Mr. Hicks' sister states that she wants to cut his attorney's throat. And of course this threat was communicated to the attorney. So the attorney wants to get out of the case. There's a breakdown. The trial judge basically says, well, we're ready to go, the jury's coming in, we've got some witnesses ready, we're going to go ahead anyway. And I believe that with the cases cited in my brief, particularly the Blankenship case and the Pruitt case, they were on page 5 of my brief, as well as the McCoy case and the Blankenship case that I mentioned. This conflict of interest, this breakdown of communications, denies the defendant, the appellant, the right to counsel. He has a right to a court-appointed counsel and someone that can assist him. He didn't have that going into this trial. Now, it turns out just a short time later, on the very first day of trial, at the very first witness, Mr. Hicks fires his attorney, says, I'll represent myself, pro se. The judge conducts a very capable, very thorough inquiry about his right to proceed pro se, and allows Mr. Hicks, the appellant, to continue. And all I can say is, and I didn't try the case, but I read the transcript of proceedings. What happened after that was basically the case devolved into a circus. There was repeated interruptions, outbursts, disruptions to the obvious prejudice of Mr. Hicks. It became especially acute during the jury instructions. Here is the judge giving the jury what they need to deliberate. The jury is trying to pay attention, and Mr. Hicks is repeatedly talking over the judge. And this goes on in the transcript of proceedings from page 351 to 366, about 15 pages of interruptions and outbursts, obviously to the prejudice of the jury. Well, the jury goes out at 11:56 a.m. I assume they had some lunch, and they come back at 2:13, 2 hours later, and they find him guilty of all counts. He doesn't present any defense, he didn't present any evidence, any witnesses, and he's found guilty, and that's why we're appealing. We believe that the judge should have allowed the trial attorney to withdraw, should have appointed another counsel, as Mr. Hicks had the right to have a defense attorney, and since he didn't do that, as the trial progressed and all these interruptions and disruptions and outbursts occurred, should have declared a mistrial. And even if you look on page 202 of the transcript, the judge brings up the notion of a mistrial. He says, in talking with the prosecutor, do you think we need a mistrial here? We could start over again, preserve all the defendant's rights and so on. There's some discussion of that. The judge decides to proceed, and again, it devolves into a circus. So that's the essence of our argument. He certainly didn't have a perfect trial, but what happened was, I think, unfortunately, an arbitrary decision on the part of the judge, an unreasonable decision under the circumstances of not allowing Mr. Hicks to have a defense attorney in these very serious charges, and allowing him to proceed pro se. Again, it's mentioned in Mr. Raley's brief that Mr. Hicks shouldn't benefit from this misconduct. Actually, and I agree with that, but the trial court judge is responsible for the conduct of the proceedings. So I think the management of the proceedings could have occurred differently instead of allowing Mr. Hicks to misbehave in front of the jury over and over again, especially all through the jury instructions. It was extremely critical.
Counsel, did the trial court explain to the jury that they should not consider those outbursts? Yes. Thank you for that question. I anticipated because it's in the transcript. The judge does ask the jury to disregard the train wreck that you just have observed. Don't pay any attention to that. He didn't actually say those words, but I think the admonishment at that point was perfunctory or not very effective. And counsel, just so I understand the position more clearly, you are not, you don't have a concern regarding the thoroughness of the inquiry when the judge did allow him to proceed pro se?
No, I don't. I think it was by the book. I've appeared in this judge's court before. I know he's a student of the law. He's an extremely capable jurist, and I have confidence in his ability to conduct that inquiry. I have no problem with it.
When the issue of mistrial came up, and at least there was some discussion with the prosecutor and the judge, did Mr. Hicks have any comment about a mistrial at that point? Didn't want one, wanted one, was silent about it? What did he say?
I believe the record indicates that he was silent during this period. This was a colloquy between the trial court judge and the prosecutor. At that point, Mr. Hicks was proceeding pro se, and of course, he's essentially inept as an attorney. I mean, he has zero experience, zero education. I mean, he more or less is hapless at that point, just outbursting and disrupting.
And just one more point of clarification.
Yes.
Yeah, your argument that Mr. Hicks is entitled to
Yes.
counsel, of course. And at the beginning of the case, at the beginning of trial, he did have counsel, correct?
He did for about 20 minutes, during which time the counsel was explaining why he wanted to get out of the case, why he didn't want to try the case. He doesn't care to try it. He made it very, very clear. And in Mr. Raley's brief, he talks about how he says that Hicks moved for new counsel on the day of trial. Mr. Hicks did not move for new counsel. What happened was Mr. Hicks' attorney moved to withdraw. Mr. Hicks did, the attorney, there was not a motion for new counsel, there was a motion to withdraw. So, and that was denied by the trial court, and I think that's the flaw that resulted in the subsequent circus, and not a perfect trial, but not a fair trial for Mr. Hicks. And we are asking the court to reverse this and allow the state of Ohio wants to prosecute Mr. Hicks. Let's get him an attorney that they can communicate, have trust and confidence, and give him all the rights that any criminal defendant is entitled to.
Thank you so much, Mr. Meyer. You're running into your rebuttal.
All right, I'll stop. Thank you.
You may proceed, sir.
Thank you, Judge Sutton. Again, I'm Rick Reilly on behalf of Lorain County Prosecutor J.D. Tomlinson at the state of Ohio. The legal maxim that applies to this case is that a litigant cannot take advantage of his own error or his own misconduct to get the outcome that he wants. And that is apparent throughout this proceedings. These outbursts, these activities were all from the defendant. And the trial judge did the best that he could to keep it under control, and he instructed the jurors not to consider those outbursts when considering this case. Because of that, this court has to affirm the trial court's judgment.
Counsel, are we putting the cart before the horse here in regard to that? Because it seems like there's no doubt that, I just want to mention too, by the way, we have two former judicial attorneys that work for the 9th District Court of Appeals. So thank you for your service, both of you.
Thank you.
But at any rate, are we putting the cart before the horse because of the fact that he was representing himself after his counsel moved to withdraw, and the court denied that right to withdraw?
So I think that some of these procedural facts are important to consider when addressing that. First off, it was 14 months that this counsel had been appointed to represent Mr. Hicks. He did not raise any issues about a breakdown in the relationship until the day of trial. That raises a presumption of bad faith in the motion. This was the second trial date that was scheduled. It is after there was a warrant previously issued because the defendant failed to appear. The second trial date is scheduled after the defendant is having contact with the minor victim's family to try to get her not to testify. The state had assembled its witnesses, a veneer of 75 individuals from Lorain County, where we came in to serve as jurors. Everything was ready to go, and there's a statement that there's a breakdown in the relationship, and the defendant says that there's a breakdown because of how a bond hearing from 4 months previously occurred, how the outcome of that was. None of those factors support overcoming the presumption of bad faith that attached to the request that morning.
Counsel, what about the fact that defense counsel alleged the day before that defendant's sister had threatened to slit his throat?
I agree with the trial judge that that's clearly the sister in him had an issue. That did not come from the defendant.
Well, can you just divorce yourself from that when you're trying a case that a close relative is threatening to cut your throat?
I think that in that circumstance, because oftentimes families of clients can be very difficult, although I have been primarily a prosecutor in my career and in private practice, it is difficult dealing with families members of clients sometimes. That does not necessarily mean that you cannot work with the person who is standing next to you. And I would also point out that it is true that he did not actually handle that case for very long because the defendant affirmatively wanted to represent himself in the middle of the victim's testimony. So
But
those
could that
factors.
also be regarded as further evidence that the relationship had broken down? That it didn't take over 20 minutes for him to ask to proceed pro se?
Correct. Well, Judge, I would say that it's further evidence that Mr. Hicks is a volatile person. And that's what's apparent from this transcript, that he is the one who is injecting problems into this case. And that's why he can't take advantage of it. So I would say that the issues you're raising, you know, they make it so that there's an issue with Mr. Hicks and his behavior. It's not an issue with the legal decisions that the trial judge made. And I agree that this trial judge is by the book. He is a scholar of the law. He did the best that he could, and even with all the experience he has on the bench, these outbursts continued. So that all speaks to Mr. Hicks. It does not speak to a legal error, in my view. So, you know, unless there's further questions, I would rely on the fact that all of the issues that Mr. Meyer raises to this court come from his client. It was his decisions, his actions. He should not get the benefit from those actions.
Any questions?
Thank you, I ask you to refer.
Mr. Meyer, you have just under 5 minutes. for
Very
your-
well. The idea of bad faith is something I want to discuss briefly here. There was no bad faith on the part of Mr. Hicks' defense counsel, as far as I could see from the transcript. I believe Mr. Hicks' attorney, in good faith, brought to the court's attention the problems that they had encountered, the breakdown in communication, the lack of trust, the fact that Hicks regarded that attorney as another prosecutor in the case, the fact that the sister had articulated a threat the night before, okay? There's no bad faith with the trial attorney bringing this to the court's attention. Now, yes, Mr. Hicks was under a lot of pressure here, he misbehaved, there's no doubt about it. That gets to the imperfect trial that he had. But it's not a case of he should get rewarded for his bad faith, his behavior. What should have happened is the trial court should have allowed the defense attorney to withdraw from the case. As inconvenient as it would have been to say, okay, we're going to continue this trial, we're going to get another attorney in here, and we're going to have a trial. Or in the alternative, as the trial was devolving into the circus atmosphere, this constant interruptions and outbursts and bad behavior on Mr. Hicks' part, a mistrial could have been called. A mistrial could have preserved all the constitutional rights, and again, it would have been inconvenient to continue a new trial, but it would have preserved the right to counsel that Mr. Hicks should have had from the outset. Yes, he was allowed to proceed pro se. He did a terrible job. No defense, no witnesses, more outbursts. And the transcript is replete with many of his references to his problems with his trial attorney. He was trying to call witnesses. He wanted the judge to be a witness. He wanted the bailiff to be a witness. He wanted various complaints that he made to be addressed, and it was just, like I say, a circus. It only took the jury a
He
couple
wanted the
hours.
judge and bailiff to be witnesses regarding the difficulties he had with trial counsel or something else,
You know,
out of curiosity.
I think at some point he's got, he wanted to get these witnesses. I think it's right around page, page 310 to about 330. He was complaining about they wouldn't give me time to prepare. I wasn't allowed to use the law library over at the jail, and so on. He's you know, the judge denied his request for these other witnesses, and we're not saying that that was an error, but
I guess I asked because I had the impression from the briefs at least that the issue of difficulties between trial counsel and Mr. Hicks was not raised until the day of trial. This isn't something that's been ongoing for a while where Mr. Hicks would come to court saying, hey, this guy or this person, this attorney isn't helping me at all until that day of trial.
As far as I know, what Mr. Reilly said is correct. The trial, the day the trial began, I think there was 14 months from the initiation of the charges to the date of that trial. And it wasn't until then that the attorney brought this to the attention of the judge. But I think if you look at the transcript, it's very specific about what the problems were: breakdown of communications, lack of trust. He thinks I'm another prosecutor, and his sister is threatening to cut my throat. Aside from that, I'm ready to go. No, he wanted out of there. I don't care to try this case. His exact words.
Was he the attorney who stayed on as standby counsel, or was there another attorney appointed as standby counsel?
No, he was appointed standby counsel, and then Mr. Hicks says a couple of times in the record, like, he's not my lawyer. He's, at some point, the judge says, well, you and your lawyers, and then there's an outburst, he's not my lawyer, so, again, this was part of the circus, unfortunately, that happened.
And counsel, with respect to what what your client said, the prosecutor, or prosecutors have indicated, the state has indicated that it was, his objection to counsel was based on his performance at the bond hearing.
Well,
is that correct?
He did mention that the attorney didn't show proper respect or consideration for his client at an earlier hearing. I think the bond was set at a very high amount, $300,000 or something like that. And I don't know what was said. I wasn't, and I couldn't get that in the transcript. That hearing apparently was not actually transcribed. I tried to get that, but so I don't really know when the breakdown occurred. I mean, I know that on the day of the trial, it was complete. It was an absolute no attorney-client relationship at that point.
Okay, thank you. And you're a little over time.
All right,
because
sorry.
I asked you a question.
All right, very
So
well.
thank you very much.
Have a good day. Thank you so much.
Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. On the day that it is released, it will be posted on the Ohio Supreme Court website, and the clerk of courts will mail a copy of that decision to both of you. And you're free to go, but thank you very much for your